Okay?
Mayor, go ahead and repeat that for the record.
Yes. Welcome to the city of West Miami. Today is, actually, this is the
June 25.
Charter Review Board. Today is Wednesday, June 25th, 2014 at 5:42. Pledge of Allegiance. Can we stand up and face the flag, please? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Yes, Mr. Mayor. Mayor Eduardo Muiña.
Present.
Vice Mayor Juan Blanes will be late. Commissioner Candida Blanca.
Yes.
Commissioner Luciano Suarez is excused this evening. Commissioner Rhonda Rodriguez.
Present.
Member Rafael de la Rosa.
Present.
Member Maria Diaz has requested to be excused this evening. Neida Galvez, absent. Frank Hernandez.
Present.
Frank Hernandez.
Present.
Okay. Ralph Orell. Absent. Joan Parker.
I'm here.
Evelyn Paz.
Present.
Irene Rodriguez.
Present.
Alex Soto.
Present.
Mitchell Surriain.
Present.
Yolanda Aguilar, City Manager, is present. Jose Villalobos, City Attorney, present. And the City Clerk is excused. She is on vacation.
Thank you.
Lucky her.
Citizen presentation. Okay.
None this evening.
Item 4, approval of the minutes of June 18.
Mr. Mayor, the City Clerk has asked for a deferral of those minutes until the next meeting so she can come back and present those as soon as she returns from vacation.
Okay. They have been deferred. Unfinished business.
We have none this evening.
Okay. Item 6, new business. Item A, remarks by the mayor. Let's do this very quick, and so we can finish the charter review. That's my remark, and thank you for your time, like always. I know that we all have a busy schedule, and I really appreciate you being here. Item B.
Item B is a schedule of the next Charter Review Board meeting, July 2nd and July 16th, 2004, if needed. Are you all okay with 5:30, July 2nd?
Yes.
Okay. You will receive an agenda hopefully on Friday of this week from my office. The next item under new business, it would be 6C, is revisit issues discussed at the Charter Review Board meeting of June 18th, 2014. And we have a follow-up by the Office of the City Attorney and a legal opinion regarding dual office holding, the city manager acting as ex-official city clerk in the absence of the city clerk. We should note that Vice Mayor Juan Blanes has just arrived.
The answer to the question is that the city clerk should appoint as many deputy city clerks as she wishes, excluding the manager. Excluding the manager.
Okay.
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 So, Mr. Villalobos, does that mean that the city, the Charter Review Committee should look at
Thank you.
placing an amendment to the charter, because the charter says the city manager shall serve as ex officio clerk in the absence of the clerk?
Correct.
Okay.
Okay.
I'm going to have an overview of the qualifications and section 6.01 on the elections.
May I go to the next item, or would you like to take this item?
No, go ahead.
Okay, the next item, just to follow the order of the agenda, Mr. Mayor, would be 6, under new business, 6D, review Article 5, finance and taxation, and that would be sections 501 through 5.15, and that's a report by the city manager. The finance director and I sat down and we looked at this article of the charter that deals with pretty much our fiscal responsibility. And because state law references and basically governs our fiscal year and our budget submittals and the dates where all these submittals take place, I would yield to the board that we leave these items. There are no recommendations on any changes on finance and taxation because we are governed by the Department of Revenue, which is a law created by the Florida statutes.
So in other words, what you're saying is that pursuant to your research, we should not have any amendments to the charter on the Article 5, finance and taxation.
That is correct.
Okay.
City Attorney.
Then we'll go to Article 6, which is qualifications and elections.
I apologize. May I interrupt? I just want to make sure we didn't gloss over. Going back to item C, you said that it is the opinion that we should change the wording, but we didn't. We didn't have a motion. No one second. No one agreed to change.
Oh,
the
I'm
wording.
sorry. You're totally right.
Okay.
Thank you.
My pleasure. Is there a suggested wording change that we're going to do for that section?
I would yield to the city attorney.
No, if you have no recommendation, that would be an approval that section Article 5 stays like it is.
No,
we're talking
about
No.
revisiting the issue of the city manager acting as
Oh.
ex officio city clerk in the absence of the city clerk.
Correct. Yeah, we should have a motion and a second.
4.4. Okay.
Act
4.4.
for official
Correct.
clerk of the city during all times.
Should we put language specific? Mr. City Attorney, your research basically says that equates to holding 2 offices. I'm imagining that's where your legal opinion comes from.
Correct.
So should we put language specifically disallowing that, or should we just not mention it at all?
May I offer something for the consideration? I believe that we should be eliminating or voting or putting a motion on the table to eliminate section K under 4.04 powers and duties of the city manager. Because that deals strictly with the appointment of an ex officio clerk of the city at times when there's no appointed clerk, and it basically gives the responsibility to the manager. Wait, give me a second. Act as ex officio. Yes. 404 under powers and duties of the city manager talks about acting as ex officio clerk.
Point of information, could the manager nominate a clerk, obviously, besides herself?
No.
As general manager of the city, doesn't she hire and appoint people anyways?
No, because she does not respond to the clerk. The city clerk does not respond to the manager, responds to the commission. The city clerk may appoint as many deputy city clerk as she wishes. But let me look at that a minute, please.
I think I agree. Kay should
If you look at section C,
This is no longer a duty of the city manager.
put it under the clerk.
Yeah, which is already there.
Which is already there.
It's under C. It's under
Right.
City Clerk 4.05C.
Yeah.
we need a motion to
Okay, motion to eliminate
Section K.
4.04K. Eliminate it completely. Second.
all in favor.
All in favor, say
Aye.
Okay,
Now,
motion passes.
may I call your attention now to 4.05, parent C.
Correct.
He's there.
Okay? It says the city clerk may appoint such deputy clerk as many from time to time necessary to carry out the duties of the office.
And that covers
That will cover it.
everything. So no amendment to that section should be
No.
necessary.
Correct.
Okay.
And then to follow up with D, I think we also need a motion and a second regarding leaving that unchanged. So I'll go ahead and motion. We're referring to the city manager's recommendation that there be no changes to finance.
Second.
Okay, all in favor say aye.
Aye.
Okay, motion passes.
Okay.
The next item would be under new business, item 6, and that would be 6E, review of Article 6, qualifications and elections, section 6.01 through 6.05.
Okay. 601, non-partisan elections, all qualification and elections in the city office, for the office of city council shall be conducted on a non-partisan basis without regards, my glasses are foggy, for or designation of political party affiliation or any nominee or any nomination of political or petition or ballot. I don't see any changes in that.
We should hold.
Yeah,
Yes.
we take a,
A motion to approve?
Oh, motion to approve.
motion to approve,
Motion to hold. Motion to
Yeah,
hold.
to
To take a
take
break.
to take a break.
Right.
Okay, second?
I guess I can take
I
a
Okay.
second.
All in favor say aye.
Aye.
Okay, so we're back and we're discussing item
6.02.
6 point what?
6.01, there was no
6.01,
change.
okay.
So we're on 6.02.
There was a motion and a second, Yolanda. Would you take the names who?
Yes, who motioned the,
No, I think she
to leave as is?
motioned to take a break, I believe.
No, we motioned to
Could have
take
been
a
both.
break.
Okay.
Could have been both. I kind of just clumped them together.
The city
That's the
attorney
general motion.
has opined that there's no reason for any changes to 601, correct, Mr. Villalobos?
Correct.
Do I hear, is there a motion?
Motion. Second.
Who seconded? Evelyn?
Evelyn did.
And all in favor, please say aye.
Aye.
All opposed?
Okay, motion passes.
Okay. Mr. Villalobos, then we go to 6.02, qualifications.
Qualification. The candidate for the office of city council member shall qualify for such office by filing a written notice of candidacy with the designated official at such time in such manner as may be prescribed by ordinance. I don't see any problems with that.
I have a question about qualifications. Shouldn't there be some sort of a qualification? I mean, Joe Blow could walking off the street and say, hey, I want to be the mayor, or I want to run for the office, or be on the commission. At least have an age limit, something that, because Mr. Blanes, Vice Mayor Blanes, pointed out a couple of meetings back, the gentleman who was running against you had absolutely no knowledge of anything about the city, according to what Vice Mayor Blanes said.
That was a fact.
Right?
And that's a fact.
Yes. So I feel that there should be something that says he's got to be at least a resident for X amount of years in West Miami, or he's got to be X amount of
Joe,
age.
that's actually
Yeah, it's in
covered,
there
that's
somewhere.
not covered here, but it's under the qualifications for each office. If we already discussed that when we were talking about qualifications for commission. Remember that we changed the years from,
Yes.
I'll show you.
I'll take your word for it.
Yeah, but no, so you feel comfortable. What is it?
Section 302.
I don't have the minutes with me. I believe that you all
Yes.
approved an amendment to
We
that.
added even age and everything.
Yeah.
Right, we changed
Right,
it to 2
and that
years.
would be to take it to 2 years,
That
and I
must've been
think
bad.
an
Minimum
age of
21.
21
Yes, it was.
and older.
It wasn't that you were out.
Yeah.
Right,
So we
so
did it.
all that will come back to you by way of
I
a
should amend it to 3
resolution.
years.
3 years.
2 years, I believe.
Yeah, but
We
we can
changed
amend
it
that.
To 2.
We changed it to 2.
But we
Right,
can
it's a
amend that.
recommendation, and that can be amended at the 11th
Yes, it
hour.
can.
For 3 years.
Right.
Let me go back to the future.
Mr. Villalobos, for a second. 602. It says candidates for the office of city council member shall qualify for such office by the filing of a written notice of candidacy with a designated official. Shouldn't that read with the office of the city clerk because she is the person, or that office is basically in charge of qualifying candidates?
I had the
Talk
same.
about designated official.
But she's the only one designated.
And it would be the office of the city clerk.
We already said that the city clerk was the elections supervisor.
So we don't have to touch this.
Okay.
That's fine.
And in order to answer a very important question is this. We had that case before, years and years ago in the city of West Miami, whereby there was a candidate that claimed to reside in the city that actually was residing, he claimed, in a home that had no water, no electricity, and he had been recently moved there and so on and so forth. And that case went to court, and the court decided that even if he lived in a hallway, that would qualify him to be a candidate. So that's what the court have ruled on that issue.
That happened here, the candidate was
Davide.
Sorry.
Don't mention names. I mean, you don't need to mention names.
Oh, I
There was an
shall.
election. There was a candidate that claimed to live in the city, and actually everybody thought that he did not. That he placed his driver's license was someplace else, and his registration for his automobile was someplace else, and so on and so forth. And it was decided that no, he did not live in the city. So there was an appeal to the Circuit Court of Miami-Dade County, and the Circuit Court judge said that even if he lived in a hallway within the city of Miami, he would qualify to be a candidate.
Although he
Water, please,
would
thank you.
disqualify.
I'm sorry?
No.
See, the idea behind this is that it's up to the citizens to be educated. You see, I agree with you that in order to participate in the political governance of a city, you should have some sort of knowledge about the city. For instance, I think that you all, this committee here, have a lot more knowledge than anybody within the city, because you have taken your time, your precious time, I should say, to come here and be interested in the business of the city. But however, that's not what the Constitution reads. So we have to abide by the rulings of the court interpreting the Constitution, the state of Florida, and the United States Constitution.
That's what I like with 3 years.
Okay, so
Okay.
6.02, no changes?
Correct.
Nothing.
Nothing.
What?
Wow, I should take a photo of this.
You should have taken a photo of me climbing on the roof on a ladder to inspect the roof during election time.
On a Saturday afternoon.
On Saturday afternoon. Now, that one there.
¿Están llamando ahí, no?
Thank you.
Okay, so are we moving to 6.04?
Three.
Oh, I
Three.
apologize.
6.03, any motions to leave 6.02 as is?
Motion.
We
to
don't
leave
need-
as- oh, we don't
we don't need a
we'll leave
motion.
it as is.
Okay.
Yeah.
Okay, let me look.
6.03,
let me-
form of ballots.
Yes, let me go ahead and look beyond this. Let me explain something. The council, it says, the council may by ordinance prescribe the form of the ballot, including the method for listing the candidate for city council election and any other city election, period. Now, I don't believe that that's a proper way in Miami-Dade County. I think that the form of the ballot is designed by the elections department of Miami-Dade County. And I don't think that we should be messing around with that in opposition with something like this because, after all, they're the one that conduct the elections. So this is something that it really should be changed. It should read, the form of the ballot shall be that designated by the Department of Election of the Miami-Dade County.
Mr. Attorney, may I ask a question? If we have absolutely no say in what the ballot's going to look like or how it's formulated or whatever, why is this even in here?
I'm sorry?
If the Department of Elections, as we all know, does the ballots, and we have absolutely no say at all, why should this 6.03 even be here?
Because it's
If-
addressing elections.
But it
I'm
says
sorry,
ballots,
I'm sorry,
form of
The
ballots.
question was directed to him. I'm sorry.
I'm just wondering.
Well, it says, candidates for the city council members shall qualify. And now, qualification is not in Miami-Dade County. Qualification is within the city with the clerk.
No, we're on,
That's
aren't we on
6.03.
6.03?
Oh, I'm sorry.
Form of ballots.
That's what you were reading. So if the Department of Elections is the deciding
Why you
office, and they do the ballots, we have nothing to do with the ballots, why is this even in our charter?
Well, respectfully, I would say, in overabundance of caution, to be very clear of how we govern ourselves, we should have a statement stating that the clerk, the supervisor of election is the one that designates the form of the ballot.
Perfect.
Well, if it's the supervisor of elections for Miami-Dade County, not
Right.
ours.
Right, correct.
Right.
Okay. So the form of, the question would be, or the suggested motion would be, the form of the ballot shall be formulated by Miami-Dade County Elections Department.
Correct.
Is that correct?
Yes.
So then we're striking everything that's there, replacing it with that.
Mm-hmm. Striking the first sentence. For city commission elections and any other city election.
Now, the next portion,
The
it-
form of the ballot shall be formulated by the Miami-Dade County Elections Department for city commission elections and any other city election. That would be the sentence, correct?
correct.
Right. And would the remaining sentences be in place, or are we replacing the entire 6.03 with that simple statement?
Well, no, because we do have to have a statement as to the charter amendment.
Correct. No, I understand. I'm saying the remainder of Ms. City Manager just read the beginning of what we're changing. My question is are we deleting everything thereafter from? Is that what the motion is? Just to replace that entire paragraph with the sentence that Ms. City Manager just read? I just want to be clear what the motion is.
I don't understand the question, but let me put it this way. We're eliminating the first sentence.
Okay.
Okay? Period. Then a charter amendment, that should be a paragraph, a separate paragraph.
Okay.
Okay? Because we're talking about another thing. See, a construction of a sentence is outside of the meaning of the following sentence. So I should say, period, paragraph, a charter amendment to be voted on or by the city shall be presented for voting by ballot title. This is good to say, even though it's already in the statutes, in the Florida statutes, but it's always good to be a little bit more clear of what our intention is. The ballot title of a measure may differ from its legal title and shall be clear, concise, a statement describing the substance of the measure without argument or prejudice. There's nothing wrong with that. Below the ballot title shall appear the following question: shall the above described amendment to be adopted immediately be adopted? That will be one question. The other one is, do you vote for approval or against the approval? So I don't see anything wrong with the rest of the section 3.03.
Okay, so then the motion should be to
6.03.
delete the first sentence.
Replace the first
Replace it.
sentence.
Delete the first sentence, replace the first sentence with the language that I so described.
Right.
Motion,
Second.
Okay. All in favor say aye.
Aye.
Motion passes.
Okay, so we're talking about elections. Let me tell you something that have been in my mind for many years, and this is strictly on a financial the point of view. I have no dog in this fight. I don't recommend one way or the other. It's entirely up to you, but it's an idea. My understanding is that a separate election from general or primary election costs more money. Is that correct, Madam
Manager, yes.
Manager? Okay. I don't know how much it is.
$20,000 is the cost of the election, give or take.
Okay. Now, one of the solutions will be to have the city election at the same time of the primary election or the general election. Okay? Well, that presents a problem. You would have to extend the term of whoever have been elected and is up for election for another 3 to 6 months. Now, how do you do that? It's a question that you have to put in the ballot, because people were elected for 4 years, and now you're saying that it's going to be elected for 4 years plus 6 months.
If I'm not mistaken, I believe we already discussed
Right.
this specific.
In the same,
Yes.
in the other section as well.
Right.
And I know that this came up to
I know,
the
but
commission, I don't know how long ago, but it
At
was
the
not that
beginning.
long ago. And the commission decided to maintain somewhat of the city's autonomy
Yeah.
to leave our municipal
Every 4
elections
years.
intact. And that's the last that I recall.
Yeah.
As did we, I believe.
Good. I'm happy, but I felt that it was my duty to advise you of this. Okay?
I mean, unless there's,
You know, I mean,
No,
this
I
is.
think the
We did that
overwhelming
already.
majority was that.
Yes.
Okay.
That was a sentence.
But I thought that I should bring it out to you, because this is the way that it should. I perceive my job to be. Okay.
We thank you once again.
Yes.
Thank you, sir. Now, let me tell you another issue about another issue, which I thought it was important, and I'm going to take it as a personal privilege to go outside of the agenda. If you go out to page 20. As a matter of fact, I don't know whether you have the same instrument that I have or not.
we will find out now when it starts talking about.
then we go by chapters down here. Let's see.
Page 20.
Page
7.
20?
7.06.
Yes.
Okay. If you have the same document as I have it, you see on top it says West Miami Code. It doesn't say West Miami Charter. Okay? Now, go out to the paragraph immediately.
Excuse me. 706 está on page 19.
I'm sorry?
Está on page 19.
No. Go out to the last sentence on that section, 7.06.
Okay.
After it describes what the function of the Charter Review Board is, the last sentence reads, and I want this to be addressed now so you know what we have to do in the future. Each board shall be terminated and disbanded once it has made its final determination to the City Council. In other words, the way that it works in the city of West Miami, according to our charter, in other counties and other cities, the City Commission appoints a charter review. The charter review makes recommendations to the table. The table may or may not accept the recommendations. As the prime example is that we had a charter review board in Miami-Dade County about a couple of years ago, and everybody appointed a number of people, and after I think it was a year and a half or something, the committee recommended like 50 recommendations. And then we went out to the commission says, no, I don't like that. I want to reduce it to 5 or 6. Okay? So to them, it's not mandatory. But if you read further here, it says, each board shall be terminated and disbanded when it has made the final recommendation to the city council. Now, the city commissioners here and the mayor here is not sitting as mayor or city commissioner. They're sitting as a member of the Charter Review Board. Then it goes out, comma, which determination shall be binding upon the council and may not be amended by the council. In other words, whatever you determine here is going to go to the table, and it has to be approved the way that you have recommended. Okay? After that, by resolution, they will advise Miami-Dade County Supervisor of Elections, and they will put it in the ballot. Okay? But I just wanted to bring that now, since we're talking about elections. Okay?
And that means basically, when this board is finished as a committee, it basically, by resolution, or no, by motion of the commission and a vote by the commission, the board ceases to exist as such.
But the recommendations are binding.
Correct.
Okay? So this is why I was, in Petit Comité, I was talking to some of the members, which I really don't know whether I broke a sunshine issue. I apologize if I did. I'll report myself to Mr. Santorino and advise him that I made that mistake. I was saying that perhaps at some point later on we should have the questions as they're going to go into the ballot for a final total approval. So there will be no mistakes as to who said what and when. Okay? So at the final meeting on July the 16th, we should have all of the questions. Okay? And at that point, we'll try to circulate that before that meeting. And at that point, the actual question that is going to go in the ballot is going to come before you, and you will say yea or nay, or I might have this issue. I suggest that at that time, we don't rehatch or reinvent the wheel, but simply we would say, I don't like this. Immediately thereafter, without further discussion, it will go out on a motion to approve or disapprove, because we don't want, again, to have another session as if we were examining that particular issue.
In other words, we're fine-tuning it, right?
Correct, ma'am.
Thank you.
Yes, sir.
Is that in here?
I'm sorry?
Is that suggestion in here?
No, it is not.
Should we put that in the procedures of?
No.
You wouldn't say a final.
No.
Some of the procedures.
I don't find any need to put it in the charter. Okay? Now, election laws are very, very not difficult, but complex. Okay? And we want to make it as easy as possible, because that's a fundamental right to every citizen of the United States to have an opportunity to express themselves, to vote, or to be elected. So even though we have finished Section 601, 602, or 603, I still have several things in my mind that I need to filter out and dilute, and that I will bring out to you if I deem necessary, okay, at the following meeting. Now we go to Section 6.04, which I suggest to replace completely. And I'll read it. The qualified voters of the city shall have the power, part of it, not completely. The qualified voters of the city shall have the power to recall and to remove from office any elected official as provided by general law. To that, I agree totally. Okay?
Mr. Villalobos, it says here, any elected official of the city.
Of the city,
as provided
by general law.
by general law.
Okay.
The copy that I have that has been stricken.
I'm sorry?
The
Yes.
copy that I have that has been stricken.
Yeah.
So at some point, we just,
Yes.
It written in Florida
And
statute
the
says
notes that I
applicable.
have read, the
That's what they
qualified
gave out
voters
today.
of the city shall have the power to recall and to remove from office any elected official of the city as provided by Florida statutes as applicable. That is the language that
That was
have
suggested by
by Mr. Villalobos.
Yes.
Is that the correct language?
That's the correct language. And to add, this last item, no recall petition against such officer shall be certified within 1 year after he or she takes office, no within 1 year after a recall petition against him or her have been defeated. The issue to include this,
that's the copy that we have, so
okay?
just want to share with you.
The reason that I'd like for that to be included is that somebody loses an election, and the following day they come out and refile again, and they lose again, and we have to spend another $20,000, etc. Okay? You have to give an opportunity to whoever is running to, if elected, they have to have that opportunity to prove themselves. Amendments by the charter. I'm sorry.
Wait.
I'm sorry. I'm going too fast.
Yes.
You need a motion.
We need a motion.
The section that you're talking about is from, on this page that was handed out to us, it's in 7.
Number
No
7.
recall petition against such an officer shall be certified within 1 year. That's the language that you want to put into 6.04?
Yes, sir.
Okay.
And obviously, we need a motion to add that language, because I believe there was a motion at the last meeting to change the first sentence under 6.04 titled recall.
Right.
So that would be a motion to add the language as dictated by Mr. Villalobos on the recall petition.
Correct.
Okay.
Is there a motion on the table?
Motion.
Second.
Who made it, Evelyn? Evelyn. And
Second by
Commissioner,
Candy.
seconded. All in favor?
Aye.
All against?
Okay, motion passes.
So just putting the language in.
Understood.
That takes us to 6.05.
This is from the Florida.
The city may amend as provided by Article 5 of the Metropolitan Dade County Charter. It should read 5.03.
03. And that is also part of the notes that were taken at the last meeting regarding amendment of the charter.
Okay.
So that was already changed.
Do we need to make a motion, or that was?
That was already done at the last charter review board meeting.
Okay.
Okay. That completes section Article 6. Now, we have Article 7, which is presently 6:25. We have still some time. If you want to proceed, we'll just go ahead with general statements here.
Okay, Paul, everybody, are we willing to stay? I know some people need to leave at 7. It's 6:25 right now. Or
I can stay at 7.
7? Okay, so let's move on.
Okay.
Then, Ms. Aguilar, can you add?
Yes,
Because it's not in
the
the
agenda
agenda.
will be amended under new business, and we will add section 6F to the agenda, commencing with Article 7, General Provisions.
Right.
Starting with section 7.01, validation of prior official acts.
It is my understanding that in prior charter reviews that have gone out to the electorate, there have been several changes that are not reflected in the charter that we have presently. I have requested from the city manager to instruct the city clerk to further review past actions by the electorate so we can have a clear understanding of what the present charter is. Because my understanding is that there might be certain changes. Is that correct, Madam Manager?
That is correct. There have been some changes that are not inclusive of this last supplement.
Francis, I'll call your attention to one specifically that I certainly hope that the mayor is sitting down.
I am. Go ahead.
Okay. Article 8.07. Elected office of the mayor is abolished.
8.07.
This is in total contradiction with what was first said that the city commission should be composed of a mayor and 4 commissioners. My understanding, pursuant to the recollections of the city manager, is that the electorate already addressed this issue, and this was voted out. But I mean, certainly,
Still here.
it's still here. But as I say, Mr. Mayor, I don't know whether you're here or not.
So I think the message is, actually, this has got to be a republication issue, because this was already presented to the voters, and the office of mayor is a separate office than that of a city commission member.
As a matter of fact, I would suggest
This is incredible. I'm
well,
reading it
anyway,
again.
let me go by section here.
I wasn't even living in the city back then.
That was way back when.
Yes, I'll tell you. See, it. A constitution is not to define issues that can be determined by ordinances or by general law. A constitution simply, the United States Constitution is actually one of the shortest in the world, and it's one of the best organizations in the history of mankind. In Section 7, it bothers me that we have the definition of authority of this city to declare nuisance and require abatement thereof. I mean, that's a subject for an ordinance. It should not be in the constitution of the city. That should be an ordinance, okay? The authority to establish a lien for non-payment of services charges, that should be an ordinance. It's unnecessary to be in the constitution of the state. The separability clause is necessary because what it says is that if any section of the city charter is declared unconstitutional, the rest of non-addressed portions of the charter that was not affected by the determination of being unconstitutional will survive. So the separability clause is a total must, okay? The validation of prior acts, it's a standard way of saying anything that had happened before we ratify that this is the way that it is. I don't think that it should be changed. So my recommendation on 7.01 and 7.02 is to leave it like it is.
What happened to 8.07 that we were talking
No, we're
about?
going to go back to that one, believe me. I don't
Okay.
forget about that one.
We're gonna address it when we get there.
Okay.
We're gonna address it when we get
Oh,
there.
yeah.
Okay, perfect.
Okay.
Yeah, no. No,
Okay.
he read my mind. I mean,
Okay.
Okay.
so what about 7.3?
7.03.
I think that 7.03 should be an ordinance. And I think, as a matter of fact, I think that such ordinance already exists.
I don't know. I cannot answer that. We can come back and give you a report on July 2nd.
Okay.
7.03.
And 7.04,
Report on it. We are not going to make a decision?
No. So
Okay.
we're gonna defer 03 and 04.
Right.
Just so I understand, Mr. City Attorney, what you're saying is that the
That this section doesn't belong in the charter, it belongs in the code.
right, that the commission already has the power, the commission already has its power to declare ordinances, and these are items that should be, that the commission already has powers to do under their rights to issue ordinances.
Right.
and I tell
If I
you,
understand you correctly.
correct. And I'll tell you now my conflict, okay? I have to weigh as an attorney on both sides. Believe me, I can argue the same issue front and back, up and down, at any point, with equally emphasis and effort, okay? But I have to tell you what I have in my mind because this is my duty and this is what you expect of me. Total transparency. There might be a problem when you say when the city provides services, etc., and you don't comply or you don't pay, then it becomes a lien, and we may foreclose on the property, and so on and so forth. If we have an ordinance today that establishes that I have read, and there was a debt before the ordinance that I established today, we cannot retroactively apply the ordinance that I just passed on past actions.
Understood.
Did I explain myself?
Yes.
Okay. In other words, it's totally legal for me to drink a Coca-Cola. I cannot today or tomorrow state that anybody that drank a Coca-Cola tonight had committed an infraction.
Understood.
That happened to me in Cuba, by the way, and they beat the living craps out of me because I said that. Because they were passing retroactive laws with retroactive effect. So I have my issues with taking it out, okay? It doesn't belong here. It's superfluous. The same with the next one, 7.04. But it leaves me in doubt of what happens
Understood.
if I take it out now with prior violations of the ordinances. You understand?
Understood.
So in the abundance of caution,
what
we
about-
should leave it.
Well,
No, we're going to
We should touch it.
defer until July 2nd.
Oh, we're gonna do.
May I,
yes, go ahead.
may I say something?
Yes.
I believe that we're looking, maybe not, but I believe we're looking at something, and look at the top of the page, it says West Miami Code.
Yeah.
No,
Well-
but I went through it, and every other page says West Miami Code, the next one says Charter.
Charter.
West Miami Code, Charter, and that's one of the comments that I was gonna bring up.
Right.
Well,
And what
the-
I
For whatever
believe is
reason.
happening is that there is a commingling of code items with charter items.
No.
No.
I did check that, and as a matter of fact, I went out to Municode,
That's what I'm on right now.
and I pulled it out,
Okay.
okay? And it's the charter, but it does have the same thing. It has code. Okay? So when it was sent out there was a misprint, I believe, because one of them says charter and the other one says code.
Every other one, just like the nurse says.
Yes.
Every other thing.
Yeah. I'm a graphics guy, so I just threw
It was
it
interesting.
for consistency, so. If it
So-
was a single page, yeah, but it's a consistency.
Right.
I would respectfully request that you afford me sufficient time as to further debate, and I'll attribute my lack of sleep and to you guys and my duty of being honest to the city. Okay?
And I guess an important part for that would be, is there already a
Ordinance.
code? If there's already an ordinance,
Right.
In place.
And I
place.
believe there is,
I guess.
specifically to the one that goes to the issue of nuisances, because that is all dealt with under the code enforcement, and some of you may have had dealings
Oh,
with
all this
as
language-
part of the code enforcement board.
Vice Mayor, this language looks familiar, right?
Okay.
Right.
We go further to.
Mr. Villalobos, just to note, we are going to check to see whether 703,
704.
704, let me mark this down,
Can be strict.
in its entirety, 704 commencing with A through A4 and inclusive of B, 1, 2, and 3, and C, correct?
Correct.
All that will be checked to see if it's covered by a city ordinance.
Now, let me
Should
tell
we-
you.
Should we bear in mind what the attorney said about if we take it out?
That's what he's gonna, that's what he's
No,
going to.
no, that's why it's gonna take.
That's what he's gonna
If there's
reserve.
a
Oh,
duplicity,
okay.
if
Okay.
if there's
Already
a
in the books.
duplicity, then we can take it out.
Okay, okay.
And let me tell you what the primary, an issue of primary importance is here.
Where are we?
I think that you took my cheese.
I'm sorry?
But that's a book, the name of the book. You took my cheese.
Yeah, there you go.
Anyway, I was looking for it, but anyway. One of the important things on the 704 703, I'm sorry. In the last sentence of 703, this is the most important issue. And let me tell you why. The last sentence says, such liens shall have the same priority and dignity as real estate taxes. Let me tell you why this is important. When we lien a property for code violations, if I lien the property today, and yesterday there was a mortgage that inures against that property, my lien is secondary to the primary interest of the mortgage that was filed. Okay? I don't care how egregious or egregious is the violation, but if I have a lien filed, the state of Florida is a notice state. So whatever is in the, if I give a mortgage and I don't file it, and somebody comes later and files another mortgage, I lose my money. Okay? If I lien a property, if I fine a property because there was some sort of code violations, and there was a prior mortgage, I don't have a power to enforce the lien that I have filed. However, the authority to establish a lien for non-payment of services is another matter. We're talking about water services, sewer service, electrical service we don't have, trash collection, garbage collection, and all of that. Okay? The last sentence reads, such liens shall have the same priority and dignity as real estate taxes. Meaning, if there was a mortgage a year ago, but I filed today a lien for services, my lien has the same right as real estate taxes, and I can collect
It
From-
precedes the mortgage.
and defeat the mortgage.
Right.
Okay? And we do that every day. Okay? So this is a most important sentence. Even though it's very short, it's one of the most important sentences in the whole
In
article.
703, such lien shall have the same priority and dignity as real estate tax.
Right. And I just wanted to mention that it's just for your knowledge, okay? The Charter Review Board.
Can we go back to the, before we go into the next?
Sure.
Yeah, can we go back to the heading? Shouldn't we address the heading?
General provisions?
No. Where it says West Miami Code, and then the next page says
Oh,
charter.
we have to cure that by the clerk and Muni Code.
Right.
Okay.
It
Do we need to
says-
make a motion for that?
No?
No.
No?
No?
Okay.
We need to make sure that things that belong in the charter are titled as charter,
Mhm.
the charter portion of the code of ordinances, if you want to call it that, and separate the charter from the code of ordinances.
Okay.
I believe I know where it comes from, just by bookmark. When you go to Muni Code and you pull up West Miami, it's the code, the chapter is West Miami, Florida Code of Ordinances. Then the subchapters of that is Part 1, Charter, Part 2, Code of Ordinances. So I believe it's the way Muni Code is coding the West Miami, bucket of documents.
Right.
Is that they're coding the whole thing as Code of Ordinances, and then under the Code of Ordinances they have two parts: Charter, and this is, I'm just seeing this right off of the Muni Code website, Charter, and then Code of Ordinances. So I think it's just by the way they've titled and subtitled our
So when you get a
documentation.
printed version, then that comes up, is that what it is?
That was
Right,
the type of,
I'm online and I don't see anything other than what we're seeing without the. But yes, I think it's an important to clarify just so it can not be challenged.
What I did was I actually pulled, before coming here today, the from Municode, and I find that in the printing, it goes out, for instance, in the legal description of the city. It says City of Miami Code.
Correct.
So that was a typographical error. So we don't need a motion to amend the typographical error.
Agreed.
Okay?
Okay. So 7.5?
Well,
7.05,
Mhm.
yeah,
prohibition against hiring of former council members.
that's okay.
That's pretty standard.
Yeah.
Throughout.
Yeah. Most charters have that
Yeah.
as a protection.
Makes sense.
Okay,
7.06, as provided by Section 5.3 of the Metropolitan-Dade County Charter. That will be okay. And then it comes out with the language as to the scheduling of the election. The only thing that I don't like about this, I have to say, again, it's only my opinion, not a suggestion, is that it reads somewhere, let me find out where.
Well, I have a question about Tuesday.
It says paragraph 1, 2, 3, 4 in the following page, page 20. Third line from unless shall be submitted to a special election within that time. Special elections are very costly, so I just wanted to mention that. I don't know that you can change it, but That's something that we all have to consider.
But there might be a reason you have a special election due to, I mean,
If I may,
Yeah.
Miami-Dade County Elections Department refers to the city of West Miami municipal biennial elections as special elections, if that maybe helps you clarify.
No, but what they mean by special election here is that you have your elections in April, and if there's somebody that comes and wants to amend the charter in June, you have 45 days in which to take it out to the voters again, you know. That would be, as far as we're concerned.
what are you talking about?
See,
charter?
the April election for us is the regular election for us.
Right.
Then whatever comes later is a special election that we have to consider. I'm thinking about language that would perhaps state that the charter may be amended only by petition once every 2 years or something to that effect. But I haven't thought about the language
That
yet.
would be under section 7.06.
Yes.
Mr. City Attorney, if I'm reading this correctly, we're not talking about a petition from public. It's saying what it's basically giving us a time frame for the Charter Review Board, and obviously it says that the council may. It's saying the minimum. This is the way I'm reading it, and please correct me if I'm wrong. The way I read it is it's establishing that the second paragraph that basically determines the minimum standard by which we have to review our charter. And then the third paragraph says, in addition to this minimum time frame, which you have to do, which is basically every 4 years, the city council may at any time decide that it's going to review the charter. And then it's talking about then it talks about the duty of the Charter Review Board to hold public meetings, which is what we're doing now. And then later on, it goes by the time in which we publish our recommendations for the election cycle. So if I'm reading this correctly, what this is telling me is that if this is not subject to public recall or public coming in wanting to change the charter, it's basically governing the time frame by which, so if we do not meet a specific election time frame, then we understand that it may fall under a special election, which is what we would then fall under the provisions of the section that you're pointing out. So I obviously there still is a danger that a charter review board at some point in the future may say, hey, listen, I don't care about I think we've been very conscientious about the election schedule, but there may be another board at some point in the future that sits and may not be as conscientious, and it may result in a special election as you're doing, as you're referring to. So I just want to clarify that is I have the correct understanding of what you're proposing, I guess.
The underlying reasoning that I'm, again, I'd reiterate again that I think that my duty is voice
Of course.
whatever I have in my mind. And I was going back to 3.07, which says initiative and referendum, that I don't know that you can negate the right of citizens at some point to simply petition to amend, because there's petition to amend the Constitution established by citizens. In other words, the Constitution may be amended, the Constitution of the State of Florida may be amended by an act of the legislation or by petition, if you gather sufficient number of signatures. So, again, I was just thinking out loud and expressing my concern. Okay?
Right, but I just want to, and that's obviously your expertise is what's helping us guide through all of this. But what I'm trying to understand is, I guess, what's the problem? Not the problematic. What is the suggested, or what's the dangers of leaving it as is? Is that someone can then force the commission to do a referendum to then cause a special election?
Let me correct you at one point. I have been a lawyer for 50 some odd years. but I don't know a lot. I learn every day, mostly from my clients. Okay, so whenever I have a doubt, the first thing that I do, even I have an idea of what it is, I usually say,
Let me check and get a legal opinion from the
Okay.
Attorney General's office or do some legal research.
so that's the point.
And
That
then
although
what you're trying to say, Mr. Villalobos, based on on our charter, that even if we have some guidelines in place that cover a charter review process during different times, and it sets the tone for the public hearings and then the tone for when the draft is submitted within a time frame, I think what Mr. Villalobos is saying is by proper petition, there may be another form whereby a charter review process.
not a charter review, an amendment to the
referendum,
right. Now you see what I have read this thing over and over and over again, and it still comes out the same question. I don't see anything here that it says that a citizen may petition to amend the charter. Have you? I mean, perhaps I missed.
It just suggests that every 4 years to review the charter, nobody could petition to review it.
I think that would fall under the powers of a referendum, as you were referring to.
3.07.
No, but the referendum, the petition referendum on 3.07 refers to ordinances.
Okay.
Okay. Well, for now, let's leave it like it is.
Let me mark it for your review, Mr. Villalobos.
Drop the
Yes.
bomb on us, so we're just all like,
So we're gonna leave
7.06,
7.06 for review.
review by the city
saying
attorney.
that
Okay.
there should be the opportunity for somebody to petition to have it reviewed. That's what you're saying, right?
I'm sorry.
You're suggesting that there should be, in this section, the opportunity or for somebody
The
to,
language.
the language, somebody could, if they wanted to, petition to have the charter reviewed. And that's not in here. That's only under ordinances.
I haven't seen it, and I'm afraid to suggest it because it might open the door
That would
to
incur special elections and incur.
that opens the door to a lot of nasty things.
Well, it also opens a door to having to budget every single year an unknown amount of money
For special
because it may trigger a budget cost over and above what we have in the budget, and so that would trigger
fact,
a
like,
budget
if-
amendment, or it would basically force us to budget an undisclosed amount of money or an unknown amount of money every year in the event of.
So
Yeah,
based
but
on that,
the-
do we still want to leave this for review, or do we want to?
You have to budget every year for a special election. Again, but going back
That's
to
correct.
the,
So
to the
again,
other argument.
if you budget for a special election, the problem is that
in the chance-
see, you take $20,000 away from because you can if you budget for one thing, you simply cannot use it for another thing, even though it might be a very useful issue for the citizens of the city of West Miami.
Attorney, is that your only concern with this section?
I'm sorry?
Is that your only reservation or concern?
That's the only thing. That's the only thing.
Then why should we even defer it? Let's just
Yeah.
go with your gut. I mean, you've got this so far. Why are we gonna put this up for review if right now you're saying that that's not a good idea? Put this in.
Okay.
Am I?
Is there a motion?
Am I understand?
Is that
You
a
don't need
motion?
motion. We're gonna leave it as is.
No, we're gonna leave it as is.
Okay. Is that a motion to leave it like it is?
We don't need
We
a
don't
We don't need a
motion.
motion to leave it as is,
Okay.
Change?
correct?
Correct.
We haven't,
Somebody could motion to change it.
so we don't want to change it, so we're not going to motion.
Okay. Good.
Am I? It don't-
Oh, yeah.
it don't-
We don't want to open up, we don't want to open anything.
Madam Commissioner, Madam Commissioner, thank you for
Okay.
reaching to what I wanted somebody to
You are
say.
welcome, sir. So,
We were getting there.
7.07.
Well, let me suggest that.
No changes. okay.
Sometimes,
No review, no changes.
sometimes an attorney has to do that. You see, I cannot tell you to
You
do
cannot
something.
tell us, but you were
you
trying
have to tell me
gently lead us
what is it that you
to
want,
someone to say, okay,
and I
7.06,
didn't.
no change,
I
no
said it,
review.
but I didn't.
Got it.
Lead us for consideration.
7.07 talks about payment of judgments or fines against officials, board members, or employees. The city shall pay any final judgment or fines, including the cost and attorney's fees against any official, board member, or employee of the city arising from any complaint or proceeding for damages, injury, fines, or other relief awarded as a result of any act of omission of action of official, board member, or employee in the exercise of performance of his or her duties or functions for the city, unless in the case of a court action, the official board member or employee acted in bad faith, with malicious purpose, or in any manner exhibiting wanton and willful disregard of human rights, safety, or property as provided by Florida statutes, section 111071 and 768.28.
Well, you should know what that means. The 768.28 is soaring immunity. That has a limit as far as how much you can sue the state for. I mean, a public entity for.
Excuse me a second. We got 4 minutes.
Okay.
Just point of clarification.
Transition schedule. I'm sorry. Payment for fines and so on and so forth. Again, I don't think that it should be here, but it doesn't do anything or detracts or adds or whatever. So,
Are you talking about the section 8 now?
no, 7.7.
7.7, I'm sorry. Are you recommending any changes to that,
No.
sir? No change?
So this is it.
So if we only got 4 minutes, we should probably stop here.
Right.
Yeah.
Yes?
We have,
Actually, we got less than that, 3 minutes.
So we should probably stop here.
we should be able to wrap up Article 8, transition schedule, at the next board meeting of
That's it.
July 2nd
We're done.
at 5:30, if we
Yeah.
agree on
Yes.
that.
And the only thing that has to be reviewed is 7.3 and 7.4.
Correct, and we will get a report back from the city attorney
See the light
on
at the end?
703, 704. We're gonna review for the ordinances, and on 701, we're gonna have the city clerk report on the most recent charter amendments to make sure they're consistent with your current charter.
That's yours.
And under 701, we're going to add a section.
Okay, go to the order. Anything to go to the order? Motion to adjourn? All in favor, say aye. Aye. Good night.